Joseph Jordan, Joseph Jordan.
Morning, Mr. Jordan.
Good morning.
You tell the ladies and gentlemen of the jury, please, how you are employed.
I'm employed with a dental supply company in Sanford, Florida.
You live here in Central Florida.
Yes, I do.
In 2008, June, July, August, September, in that era, sir, did you volunteer to work with Texas EquiSearch?
Yes.
Would you tell the jury, please, who and what Texas EquiSearch is?
It's an organization that searches for missing people.
Was this the first time you had been involved in volunteering to search for missing people?
Yes, it was.
Did you become a team leader?
Yes, I did.
What is a team leader?
Somebody who basically directs the search when you're out on the searches, and just lead the team.
How many people did you usually have on a team assigned to you?
Anywhere between 10 and 30.
Did you, in fact, sir, have occasion on about the 1st of September to search the suburban drive area in Orlando?
Yes, sir.
The purpose of that was?
We were given direction to search a certain area, and we searched. That was one of the areas we were given to search.
Searching for Caylee.
Correct.
May I?
You may.
Mr. Jordan, would you step down? This is exhibit number 57.
Yes. Let's get the witness mic'd up.
I object to use this exhibit with this witness because it's already been marked by another.
Do you have another one? Your photo?
There was a photo, I believe, that was not marked up.
Page 2. You know the number one you have. There's several of them. Okay, we're marking another copy of the same photograph, identification FH for the defense.
Okay.
May I show this to the witness, Your Honor?
You may.
Showing you this photograph, sir. Do you recognize the scene they're in?
Yes, sir.
Okay, are you familiar with it?
Yes, sir.
All right. I guess without using this, you can return up there and we'll do it electronically. Mr. Jordan, is that on you have on your screen of this photograph?
No,
No, sir.
it should be on the, kind of turn the screen a little.
Yes, sir.
this way, Mr. Okay.
Is it on there now?
Yes, sir.
All right. Mr. Jordan, does this photograph fairly and accurately portray your recollection of the area of Suburban Drive that you participated in with Texas EquiSearch?
Yes, it does.
All right, then I don't know how many of these we have, but I'll offer this exhibit next for the defense, Your Honor.
Any objection?
No objection.
Be received as defense exhibit number
Number 61.
Sir, when you searched on Suburban Drive, first of all, do you know how many times you did that?
I don't recall, no.
You want this,
Published to the jury, Mr. Mason.
I will, yeah.
You want it now?
Yeah, we can do it now.
it's on.
Everybody have it? Now, Mr. Jordan, when you went out there to search, this was part of Texas EquiSearch searching, not just you on your own.
Yes, sir.
Did you lead a team?
Yes, sir.
Did you lead a team on each of the occasions you went there?
Not every time, no.
First time?
I believe so.
Know how many people were on the team the first time?
I don't recall.
Was it more or less than 10?
Probably more than 10.
And were all of the people on the team also searching for Caylee?
Yes, sir.
And do you remember on the first occasion the area that you and your team searched on, relative to Suburban Drive?
Yes, sir.
Can you show us with your, how does that work? You touch it.
Okay. We would park usually down here and along this area.
Okay, sir?
The main focus of the search was along this pathway. And there, at the time, was no fence here, and we were able to go back in this area. So we were able to search that general area, and then about 5 of us came up and walked along this way, and I'm not sure how far we went up, but there was an entryway about right here that we were able to walk into,
What do you mean by entryway, sir?
an opening.
Like a path?
Correct.
Do you recognize the wooden privacy fence that's adjoining the house up to the right there?
I do, but I don't know if I actually made it all the way up to
Okay.
that point. I had highlighted everything on my
On-
Texas EquiSearch form.
On your first search, then, you and how many others actually went further on up as you drew there and to the path and past the path?
Approximately 5.
And on that particular occasion, did you go into you or any of your team go into the wooded area there off the street?
Myself, Lori Cree, Jennifer Craig, Brett Churchill. I can't recall if there was anybody else at that particular time.
Without telling us necessarily what, had all of you been briefed on what and how to do your search?
Yes.
Do you remember how far into the woods on that occasion you did with those people you just named?
I want to say about 5 feet. There was standing water. There was a red cooler and a pink baby blanket, and that was as far as we went.
Okay. You found a pink baby blanket.
Yes, sir.
And did you turn that over to the sheriff's department?
I marked it on my field activity report.
And did you turn it over to the sheriff's department?
I turned over my field activity report to Texas EquiSearch.
And, pardon?
To Texas EquiSearch.
Do you have knowledge as to whether or not the sheriff's department, in fact, responded and collected that pink baby blanket that you found?
I do not know.
Is that the only area of search that you did on the first time?
No, we also searched an area west, in this direction, across the Chickasaw Trail.
Regarding Suburban Drive, this is the only area.
No,
Pardon?
not that day, no. That was the only area. Sorry,
The area you marked is the only area on Suburban Drive you searched on the first occasion.
that's correct.
All right, sir. And then when was the second time?
Later on that day, I had a dog handler from another team come and bring their dog up that way.
What was the date, if you recall, that you took a second team out there searching?
It wasn't a second team. It was the same day, and I had brought that individual from a different team to check that baby blanket and cooler.
How many people did you bring in on that occasion?
Just one. It could have been two. I don't remember if it was the same day that I brought the two different dog handlers in.
So you brought two dog handlers into that area,
Correct.
and one of them was at least a cadaver dog, correct?
Objection, calls for hearsay response.
Overruled. If it's based upon his own personal knowledge, sir, you can answer the question.
I don't know the qualifications of the dog.
Well, did you have an understanding whether or not the dog was a cadaver dog?
Objection, calls for hearsay response.
Sustained.
You tell any of the detectives in this case that you were there with a police officer from Panama City with a cadaver dog?
Yes, sir.
And did the cadaver dog with the police officer from Panama City conduct a search in your presence, sir?
Your Honor, objection assumes facts not in evidence. The fact that he may have said that doesn't make it so.
But I just asked him if he did.
Overruled. You can answer the question.
I'm sorry, could you repeat the question?
Did the police officer from Panama City with a cadaver dog conduct a search in that area in your presence, sir?
It wasn't necessarily a search. I just had him sniff those two articles that I described earlier.
And was there a second dog also?
Yes.
And to your knowledge, sir, did that second dog also participate in a search of that area?
Again, not a full-on search, just to sniff those two articles of interest.
Were you ever taken back out there to be shown exactly the location where the remains were found?
I did go back out there with a gentleman, Brett Churchill, who pointed the area out.
And do you remember how far from the road that was, sir?
I don't know the distance, but he explained it was about 45 feet.
Objection to the hearsay.
Sustained.
Mr. Jordan, can you stand up, please, sir?
Yes, sir.
Can you see this tape on the floor here?
I can't see that
I'm
angle.
sorry, can you step down there?
Witnesses stand down.
You see the tape on the floor, sir?
Yes, sir.
Is the spot where Mr. Churchill showed you that the remains were approximately here by this brass footing from the jury?
Sustained.
Did you observe the spot where Mr. Churchill showed you the remains been found?
Same objection.
Sustained.
Do you know how far the remains were from the side of the road, sir? Did you go into the woods the same distance as you are from me now?
The entryway you're speaking of was not directly from the road.
Okay.
It was further down.
All right, go back over. What about the third time you went out there, sir?
I don't recall how many times I actually went out to that location.
You remember the third time you went there?
I don't even know if there was a third time. There were many other areas of interest to look at.
You remember when the remains of the child were found?
I don't know the exact date, but I know in December.
You remember sending an email on December the 13th, 2008 to Detectives John Allen and Yuri Milich?
Yes, sir.
What, if anything, do you remember, sir, was in that email you sent to them on that date?
I don't I remember the exact content of it.
Would it refresh your recollection to look at a copy of your email?
Yes, sir.
May I approach the bench, witness, Your Honor?
You may.
Refresh your recollection, Mr. Gordon?
Yes, sir.
What, if anything, you now recall you conveyed to the detectives by your email?
I conveyed that I believed I was in the location where her remains were located.
You remember informing them that you had 2 qualified dogs at that location?
I believed they were qualified dogs, yes.
You remember telling them that you believe the remains were moved after your search?
Yes, I did say that.
Do you have an approximation, sir, of how many people in total you observed searching that area?
Objection to the variance, what area?
Sustain, rephrase the question.
The area on Suburban Drive, sir, where you searched on the various occasions. Can you tell the ladies and gentlemen of the jury how many people you saw out there searching, whether your team or not?
Same objection, Your Honor. There are several areas of witnesses testimony.
Sustain, he needs to go to the diagram so we'll know.
Is it still on your screen there?
Yes, sir.
Okay. Starting on the right side, the area where that privacy fence is, you said you recognize that?
Yes, sir.
And moving down towards the school, that area. Just from there to the path that you identified, we'll just shorten it up to right there. Okay, sir? How,
No, sir.
I'm sorry, yes.
how many people do you recall searching, whether on your team or not, that specific area?
It's not actually that specific area. That was the pathway right there, sir.
The area from the fence to the pathway, okay? Can you tell your best estimate of how many people were searching that area for Caylee?
I had about 5 people walk along the side of the road there because the brush was heavy.
Other than on your team, how many people did you see there?
Objection, see where?
The area that we're talking about. Go ahead, sir.
I did not see anyone else from Texas EquiSearch search that exact area.
Other than Texas EquiSearch, sir, how many people did you observe searching the area that we have just limited the scope to?
I did not see anyone besides the people that were on my team search along that area.
Do you remember, sir, being placed under oath and providing a taped transcript of interview on or about November the 5th of 2009?
I believe so, yes.
And you remember at that time, Miss Linda Drain Burdick was present?
Yes, sir.
You,
Yes.
Corporal Edwards,
Yes.
Corporal Melich,
Yes.
Sergeant Allen,
Yes.
and your attorney, William McClellan.
Correct.
You remember on page 25, Bates stamp number 12,763, continuing to the next page. Corporal Edwards asking you, was there a mass 100 plus people that turned out on that road and did a search past the school, or the number that seems to keep coming up, 100 and 100 searchers? You remember that? Remember being asked that by Edwards?
I don't.
Does that question in your presence at that time refresh your recollection at all as to how many people were searching that area?
Like I said, the only people that searched the pathway that you've described are the amount I've already stated.
Okay, let's go back to that. I didn't say the pathway. I said the area from the privacy fence to the pathway, just narrowing that area. Okay? Can you tell us how many people
Can you
think were
explain
searched?
what pathway you're speaking about?
Pardon?
Can you explain what pathway you're speaking
The
about?
one that you marked, sir.
Okay.
From that point going up to the privacy fence. That's the area I'm talking about. Now, does that question and answer session refresh your recollection that there being 100 people or more searching the area?
There were not 100 people searching there when I was present.
And by the way, on the occasions you went out there, sir, did you know, in fact, where the Anthony residence was?
Yes.
Right around the corner there on Hope Springs Drive, right?
Yes, sir.
Did you look down there when you were going out searching?
We did drive past Hope Spring Drive and drive along that area, yes.
Were there a lot of media trucks there?
Yes, sir.
Generally, a lot of people in the area the whole time, wasn't there?
Around the house, yes, sir.
One second, Your Honor. I have just a moment.
You may.
I have just one other question, sir. Do you have any knowledge as to what was done in response, at least as far as you know, to the email you sent out on December the 13th, 2008?
No, sir.
All right. That's all the questions I have on this one.
Cross-examination.
Good morning, Mr. Jordan.
Good morning.
May I have a moment to remove?
You may.
Mr. Jordan,
Yes, ma'am.
you indicated that you volunteered with an organization by the name of Texas EquiSearch. That effort was in late August or early September of 2008, correct?
Yes, ma'am.
Before that date of your volunteering, or those days that you volunteered for that organization, you had begun to email members of the Orange County Sheriff's Office already. Am I right?
Yes, ma'am.
You had sent several suggestions to either John Allen or Corporal Yuri Melich on individuals perhaps that they should have some contact with in order to assist in the search for Caylee Anthony.
Yes, ma'am.
Okay. And that was your motivation to try to help them find Caylee,
Yes, ma'am.
because you believed that she was missing and deserved to be found.
Yes, ma'am.
Okay. You also indicated that whenever you volunteered for Texas EquiSearch, they required that you keep paperwork,
Yes, ma'am.
particularly if you are assigned as a team leader. It is your responsibility to document the individuals that went on a search with you, correct?
Yes, ma'am.
You are provided with maps of areas to search, correct?
Yes, ma'am.
You have a space on that paperwork where you can indicate what the results of the search are, correct?
Yes, ma'am.
And then there's also a space if some follow-up is needed for items that you may have found, or if there was something else of interest that needed to be checked out, correct?
That's correct.
At the conclusion of your search effort, it was your responsibility under the rules of Texas EquiSearch to get debriefed by somebody who actually worked for Texas EquiSearch.
Yes,
Am I
ma'am.
correct?
Yes, ma'am.
Did you, in fact, take the responsibility on September 1st of 2008 to be a team leader for Texas EquiSearch?
Yes, ma'am.
Have you seen your original paperwork?
Yes, I have.
All right. May I approach the witness, Your Honor?
You may.
I'm going to show you what's been marked as RM for identification. Take a look at that and tell me if that is the original paperwork that you filled out on September 1st of 2008 in conjunction with the search effort with Texas EquiSearch.
Yes, it is.
Now, at that point, you actually took very detailed notes of things that you saw or thought were of interest that perhaps somebody might want to look at later,
Yes, ma'am.
correct? Your Honor, at this point, I would like to seek permission to use this as a demonstrative exhibit during the witness's testimony so he can explain where he was and what he did.
What says the defense? Okay, you may proceed.
All right. The exhibit that I handed you was 1, 2, 3, 4, 5 pages, correct?
Yes, ma'am.
All right. I'll show you page 1 of that. I'm going to have to orient this differently, and may I have permission to publish?
You may.
Mr. Jordan, is this the field team activity report that you filled out as team leader for Texas EquiSearch Mounted Search and Rescue Team?
Yes, ma'am.
Okay, the other names of individuals that searched with you that you had referenced earlier, Lori Cree and the Churchills, Jen Craig, those individuals are reflected on this document.
Yes, ma'am.
As you move into the middle of the document, actually, where it says assignment here,
Yes, ma'am.
was a map, there are maps attached that document what assignment you were given that day, correct?
That's correct.
Is this your handwriting where it says describe search efforts?
Yes, ma'am.
All right. And does that accurately reflect the locations where you searched on this date, September 1st, 2008?
Yes, ma'am.
All right. This church, is this the location off of Chickasaw Trail that you had mentioned earlier that was to the west of Suburban Drive?
That's correct.
Right. And when you're referring to behind elementary school and then Hidden Oaks in quotes, is that at the end of Suburban Drive where you had indicated that you started or parked your cars?
Yes, ma'am.
Okay. And then you wrote dogs behind school, ATVs behind school, and dogs were not fresh used during search. What do you mean?
The gentleman that was that I had checked those two articles told me when he was having him.
Basis of objection?
Your Honor, the objection to hearsay is.
Exception to the hearsay rule?
Your Honor, we're not offering this for the truth of the matter asserted, only why he had indicated on this document that the dogs were not fresh.
Objection overruled.
Gentleman Danny Iverson told me that his dog was not fresh when he checked those two articles.
All right. But you don't know if that's accurate or not, correct?
I don't. It was the end of the day, but other than that, I don't know.
All right. Down in the portions, described portions not covered, you wrote non-highlighted area. What did that mean?
What I did was when we searched a location, I highlighted or marked an area of interest. So pretty much anything non-highlighted, we did not cover completely.
And then did you make this entry here that says 2 humerus bones?
I did. Yes.
All right. Is this an assessment that you made as to whether or not these were human or animal or?
Yes, ma'am. I checked the forensic anthropology book. Those bones did not turn out to be human after they were checked.
All right. And then did you make some suggestions for these areas if further searches were conducted?
Yes, ma'am.
All right. You said non-highlighted areas. Earlier, you've indicated that those are portions that you did not search,
Yes,
correct?
ma'am.
And you said when water recedes, research. What do you mean?
The water was about knee deep as soon as you entered into the brush, and it was just, it was, I believed it was too dangerous to have people go in the water moccasins, alligators. You didn't really know what you were going to see.
All right. Did you also have a concern that if there was something under the water that you couldn't see, that you could trample on it, destroy any evidence, or even, God forbid, step on the child's remains?
Yes, that was a concern of Texas EquiSearch as a group.
Okay. And you as an individual as well?
Absolutely.
All right. You indicated that some of the areas that you mark on your map, especially these mounds 4 and 5, need to be researched, and you also made reference to some half-buried bags.
Yes, ma'am.
Okay. Down here, is that your signature with a date and time?
Yes, ma'am.
Was that signed and dated on that time? On
Yes.
that day?
Yes.
Okay. All right, the last page of the document, if I may publish that.
You may.
I don't think I'm going to get it all in the first time we start talking about this, but do you see the highlighted areas on this map?
Yes, ma'am.
Were those highlights made by you?
Yes.
What were you intending to signify or designate by highlighting those portions?
We were given such broad areas. I wanted to make sure that I didn't just say I searched this entire location. I wanted to be as detailed as possible and say that I searched only where we actually searched.
All right. So the areas that are highlighted is where you have some confidence that you searched.
Correct.
And I'm highlighting it in red and all along this part. These are pathways
Yes, ma'am.
on this side? Okay. Now, you do have some lines with other markings. What are those?
Which lines, ma'am? The ones
See
where the
how there's
highlighted-
some lines coming into different locations?
Yes, those are items of interest we found, but I didn't highlight the entire area just because it was not thoroughly searched.
Okay. Now, is this as detailed as you got with the area where you found, does this say pink baby blanket on the side here?
Yes, ma'am.
And then you wrote cooler cleared by dogs.
Yes, ma'am.
Is that a Gap bag, the store, the Gap? Does that say Gap bag or towels? Can you see? I can try to turn it.
I believe so.
Is that the word mound
Yes.
and toys? Is that what that? And then you have arrows or lines going from those locations. Let's see if I can zoom that. Or going from those notes to a particular location. Can you see that?
Yes, ma'am.
Is this as far away from the end of suburban as you got in the woods?
Yes, ma'am.
Would it be fair to say then, let me see if I can turn it. If this is east, that the furthest west you got was about here. However far you went in.
Yes, ma'am.
All right. But it's your testimony and recollection, is it not, that you couldn't get in to the woods very far in that area because of deep water,
Yes, ma'am.
relatively deep water?
Yes, ma'am.
And these documents were created before Caylee's remains were even located, correct?
Yes, ma'am.
So when you emailed Detective Melich and Detective Allen, or both, on December 13th of 2008, you did not know exactly where Caylee Anthony's remains were found, correct?
It was speculation based on media coverage.
You saw on television that they were on Suburban Drive, correct?
Yes, ma'am.
And you knew you were in the area.
Correct. I made a mistake.
Thank you, Mr. Jordan. Your Honor, I have no other questions.
Redirect.
Mr. Jordan, did you tell us just a little while ago that Mr. Churchill took you, one of your searches, and showed you precisely the spot where the body was found?
Yes.
And you were out there, sir, you saw not only the media trucks, you saw the big blue tent of the sheriff's department people there, didn't you?
Objection deleted.
Sustain. Rephrase the question.
I'll rephrase your Honor. When you went back out there, sir, did you see the blue tents from the sheriff's department, all the people around?
No, that had already been cleared.
On December the 13th, it had been cleared?
I did not go out there on December the 13th.
You sent the email on December the 13th.
Based on what I saw on television, yes.
And what you saw on television, sir, did you see the big blue tents and all the people around there and the crime scene tape and everything?
Yes.
And you recognize that, did you not, sir? I'll fix it. Did you recognize what you saw as a scene that you have just been telling us about that you searched?
I thought it was at that time.
Okay. And by the way, you spoke about there being some water there. Indeed, sir, was the water clear
Yes, it was.
and sand bottom?
Yes.
You could see?
Yes.
Now, Mr. Jordan, do you have any present reasons to want to alter your testimony about where you searched?
Overruled.
No, sir.
Well, sir, in this investigation, in this case, were you threatened with felony prosecution?
On advice of counsel, based on my Fifth Amendment right,
You
Can we
may.
approach the bench now?
Yes. Okay, Mr. Jordan, you may step down for a moment and step outside. Okay, Ms. Burdick, you have anything in addition you would like to say?
Your Honor, the objection that I lodged was based on the propriety of counsel eliciting an invocation of the Fifth Amendment in front of the jury. I believe that that is improper, that counsel knew that the witness was going to invoke the Fifth because of the questioning at deposition that elicited the same response, and therefore I object to this line of questioning.
Mr. Mason?
Your Honor, on page 10, page number 12,740, and a sworn statement given on November 5th, 2009, as I referenced earlier, for which no defense lawyer was present. Mr. Jordan was advised by Ms. Linda Drain Burdick that the process they had issued to him, it says that gives you immunity for what you say. And they carried on in this conversation with him about his activities. I'm trying to find the resume last night. In which they discussed with him that he had broken the law. He says he knew he broke the law and was advised not to destroy the tape because he'd be breaking the law again. I did not ask him initially that, but when his testimony seemed to change, let me find the other statement. I will take you to the statement of October 28th, 2009, tape recorded interview of Mr. Jordan with Corporal Edwards. And counsel, I believe it's, I'll give you the page number 1 second. Starting on page 34. Talking about, which is Bates stamp 12,878, acknowledging that he had recorded the conversation and discussing how he did it. And then on page 36, the Corporal Edwards is asking him, and you memorialized his statement in a recording that you did surreptitiously right. And further, even with his lawyer, says it's recorded him with, the lawyer, then was Kelly Sims, recorded him without his knowledge as well. And on page 39, I contact you guys. I have a recording that I'm giving you guys that was done without this guy's permission. And on line 16, Sergeant Allen, Joe, you broke the law. Don't break another one by destroying it. Yeah, and laughter. And on page 40, a detective that was working for the defense at that time, Mortimer Smith, was asked, strike that Mr. Jordan referenced Mortimer Smith and says about recording him without his knowledge. And then he says, if it's you guys, I understand that you know it's not to your benefit to obviously go after me. That's what this witness said, and that's on page 40, base stamp, page 12,884. And so it's clear that indeed he was discussed with, under oath with the officers, he was threatened with and discussed with prosecution and felony prosecution for unlawful wiretapping. Then he's given immunity. So if he has immunity, I don't know what the status is. I'm hearing from the prosecution that means that he's not under any threat of prosecution at this time. So I have a right to talk to him about his motivations, keeping his immunity, pleasing them, and so forth. And then he took the fifth. I didn't ask him to do that, of course, and I avoided it in the beginning of the examination for that purpose. But he doesn't get to sit here and alter what I believe is alteration of his testimony or changing the specific areas he searched and so forth and say, yes, and as long as you guys don't go after me, I'm okay. It goes to his credibility. I don't know what else to do about that. I did not expect him to take the Fifth Amendment at this point in time. His lawyer's sitting right there. And I suggest to you that when Ms. Drain Burdick thereafter issued the statutory process to him and immunized him, then he wouldn't really have a Fifth Amendment privilege at that point. He's either waived it or it's not there. And certainly his actions go to his credibility. His testimony is affected by his credibility. And every witness that takes a witness stand is subject to impeachment on credibility.
Any additional comments from the state?
Only that Mr. Mason wasn't demonstrating that there has been a change between this testimony that he gave on November 5th of 2009 and any prior point in time or subsequent point in time. The objection, which he did not address, had to do with him eliciting an invocation of someone's Fifth Amendment rights, which, based on the deposition, and I can find that for the court, I believe this has been filed, Mr. Mason knew he was going to do and had indicated to me ahead of the questioning that he was not going to be asking him about the illegally recorded conversation. So I still haven't heard any response to why that question was elicited that drew my objection, and I maintain that objection.
Your Honor, the email.
Turn this.
The email that he was refreshed with that he sent, in which he told the detectives on the 13th of December, body found on the 11th, that in essence you made a mistake. In my opinion, the body was moved. Now, and further, that Mr. Churchill showed him exactly where it was, and then today he tries to testify that he was further east than that and didn't go into that area. That brings it all in conflict.
Well, let me ask this question. Was it represented to the state of Florida that there would be no questions asked of him that would tend to require him to invoke his Fifth Amendment privilege?
Not exactly that way, but close to it. I did not intend to go into him taking his Fifth Amendment privilege at the deposition, and I didn't. He decided to do it here is a different story. I didn't ask him if he could take his Fifth Amendment. I didn't ask him if he could invoke his rights to counsel or anything else. I particularly did not do that. I asked him now whether to change testimony on his credibility, and he's the one who decided to invoke his Fifth Amendment privilege here and now. I precisely did not go into his prior doings.
Your Honor, there's no changed testimony from the time of the deposition until today. So his suggestion that this is now why he's changing testimony is without merit. He told Mr. Mason that he sent the email just like he told the jury today, that he at that time believed that he had been in the area and that the remains were moved. He told Mr. Mason at deposition that he had made a mistake. He told the jury he made a mistake. He's not impeaching him on anything. He's trying to elicit something that he can't in order to suggest misconduct on someone else's part, not the witnesses.
said when he passed, he's got his
Well-
testimony from his diagrams, he's got his various sworn statements we were not part of, he's got his deposition, and, Your Honor, I did not ask him a single question about invoking his Fifth Amendment rights or privilege, anything before. I asked him only because now, is he still trying or has a reason to give freedom? I just read you the transcript. You guys don't come after me, I'm on your team. And that is something that's stored, is open for me to challenge his credibility. He chose to vote.
Both sides familiar with the United States Supreme Court case of Davis versus Alaska?
Yes.
And what does Davis versus Alaska tell us?
If there is a pending criminal proceeding that could go to the issue of bias, then counsel is entitled to inquire as to that.
I think the potential crime for which he could have been charged with was unlawful interception of conversation.
Yes,
Is that a felony of the third degree?
I believe it is.
And what is the alleged date of commission of that particular crime?
October of 2009, end of October.
And I take it he was granted use immunity from prosecution
For his statement only, yes,
for
on
his statement only.
November 5th of 2009.
And the statute of limitation for a third degree felony is 3 years under the applicable Florida state statute under chapter, I believe, 775.
I believe that's the 775.15 is the
One
time
more, what?
limitations,
It's 3.
2 or 3.
It's
I think it's 3.
felonies. It's a 3-year. The proper procedure would have been simply to proffer that particular question to see whether or not the witness would attempt to invoke his Fifth Amendment right, and then we could have dealt with that outside of the presence of the jury. It is fair game dealing with the credibility or believability of a witness to bring up the fact that that witness has been granted use immunity by the prosecution. It would have been up to the state to decide whether or not they wanted to go into the details of what he was given use immunity for, since it may or may not been a quote-unquote dastardly crime, the unlawful interception of recording of someone's voice without their permission. Mr. Mason, what is your continued line of cross-examination dealing with that particular issue? No, Mr. Mason, the objection was lodged. We approached the bench, and where do you plan to go?
With his response, I wouldn't. I would respect that and stop.
We're going to move that the response be stricken because it's an invocation in front of the jury, which is impermissible. But if he wants to ask him other questions as it relates to bias, I have no objection, obviously. But he's on redirect. He's not on cross.
Well, whatever he was on. Just a second. What is the page and line of his deposition where he invoked his right to Fifth Amendment counsel? Anybody can tell me, was it in volume 1 or volume 2? Volume 1 was December, volume 2 was February.
I know in volume 2, starting at page 74, line 3.
Volume 2, page 74, because volume 2 of what you have filed here only goes to 32 pages.
All right, that might be what's scanned, but at the top of the, at the top,
Page what now?
it says 74 on the top of my volume 2. Looks like it was continued from volume 1. Volume 1, page 28, line 7 is the first indication of an invocation of the Fifth Amendment
Okay.
right.
I see what they did. It starts at page 60. Yeah, and they scanned them in as,
And then again, in volume 2, there are several pages starting at page 74 where there's an exchange with Mr. Jordan's lawyer about not answering. Page 77, lines 19 and 20, Mr. Baez. So the privilege you're asserting is the Fifth Amendment. And that was February 3rd of 2011.
was Mr. Jordan served a subpoena by the state of Florida to appear at the proceedings here today? Or was he served by the defense?
That would have been defense, Your Honor.
Okay, anything else from both sides, either the state or the defense?
No, Your Honor.
The question that was asked of Mr. Jordan is as follows. Well, sir, in this investigation, in this case, were you threatened with felony prosecution? That particular question in and of itself does not necessarily elicit the response that Mr. Jordan gave, which is to invoke his Fifth Amendment right. He could have simply answered yes or no. But Mr. Jordan, not being skilled, simply probably had a knee-jerk reaction and simply did the first thing that came to his mind, invoked his Fifth Amendment right. Now, correct me if I'm wrong, Mr. Jordan's attorney is present here today. Mr. McClellan, to your understanding, sir, was your client given use immunity by the state of Florida in this particular incident?
For the recording, yes, Your Honor. Not for his testimony today in regards to the disclosure of what was ever on that tape.
Okay. This is what I will do. I will instruct the jury to disregard Mr. Jordan's last comment about the Fifth Amendment. The defense can inquire about receiving use immunity, but the defense cannot inquire concerning what he did to get the use immunity, because he does not have immunity. And those questions, if you ask him specific questions about what he did with the recording, would in fact require him to invoke his Fifth Amendment right.
Willing to give him use immunity for any direct or cross-examination for today. I would advise the counsel that opens up other doors, however.
It probably will open up some other doors, but when you shut one, you open many. So, Mr. McClellan, you may want to go out and talk with your client, advise them of what the state of Florida. When you finish talking with your client, come back in and let me know. It is 15 minutes afterwards. Let the jury know if they want to go ahead and take their special break now. We'll do that. And we will be in a recess for at least 15 minutes. You may be seated. Okay. Both sides ready to proceed? Okay, let's return the witness and Mr. McClellan.
It's our understanding that the court is going to strike the response.
Yeah. The response basically was non-responsive to the question that was asked. Okay, Mr. McClellan, did you have an opportunity to talk with your client, sir?
Yes, Your Honor.
Okay, and you explained to him what the state has indicated.
Yes, Your Honor.
All right. Mr. Mason? Yes, sir. Feel free. All right, state recognized the presence of jury. The defense recognized the presence of jury. Ladies and gentlemen of the jury, the following two questions have been withdrawn and you are to disregard the response. These are the questions. Now, Mr. Jordan, do you have any present reason to want to alter your testimony about where you searched? Well, sir, in this investigation, in this case, were you threatened with felony prosecution? And then at that point, Mr. Jordan asserted the Fifth Amendment right. The questions have been withdrawn. The response, thus, you are hereby instructed to disregard the last response and not to take that response in consideration. You may continue, Mr. Mason.
I have no further questions.
State,
No recross.
may Mr. Jordan be excused.
Yes, sir.
Thank you, Mr. Jordan. You may be excused.
George Anthony, George Anthony.
You may proceed.
Thank you, Your Honor. Mr. Anthony, do you know a woman by the name of Crystal Holloway?
I know her by that name and also another name,
Okay. What other name do you know her by?
River Cruz.
Okay. And how do you know her?
She came to our command center up on Goldenrod and where the skating rink is at in October of 2008.
And how well do you know her?
Just someone who volunteered at our site, sometime maybe considered her a friend or someone who was going to be helping find our granddaughter.
And how would she have gone about that?
Oh, by working at our command center, someone would come in with a tip or information that could help us find Caylee.
And is it your testimony that she was just another volunteer?
Absolutely, just another volunteer.
No different than any other volunteer?
No, because everyone who ever volunteered at our command centers, stuff like that, Some people became more than just volunteers, they became friends.
Okay. Did you have a romantic relationship with her?
No, sir, no. To me, that's very funny.
Very funny.
Yes, sir.
And were you ever intimate with her?
No, sir. That also was also very funny.
Did you ever borrow any money from her?
No, sir, I never borrowed any money from her.
Did you ever go to her house?
On 2, possibly 3 occasions, and I can explain that.
You know that you have to pass a guard gate to get to her home, do you?
Questions of other witnesses' testimony.
I didn't ask him any questions of any other witnesses.
Overruled.
Yes, sir, I can explain that. It's going to take a few moments to explain that to you.
I'm going to give
and
you
to
your.
everyone else that's here.
I'm going to give you your opportunity, sir,
Yes, sir, I'll clarify everything.
and explain to the ladies and gentlemen of the jury why you went to her apartment.
Well, she doesn't have an apartment, sir. If I'm not mistaken, it's a condominium. I can straighten that out.
Okay.
Yes, when you do arrive at her property, which is a gated community, you do have to go through a security entrance. Show an identification. Hopefully there's a pass when you're there, and you're left to go into the property. Going into the property and going to a residence or her condo, the very first time I remember being there, it was because that we had a conversation, because she had relayed to me probably weeks or maybe just a few days prior to me going there for the very first time, that she has a brain tumor. She was dying. She needed someone to comfort her, and I felt, as being a good guy, or as someone who had come to know a lot of the people inside for volunteering for us, I became very connected with a lot of them, and she was one of them. And I felt, because she was giving of herself to me and my family to help it with my granddaughter, that's the least I could do, to go and show her some compassion and some respect.
Did you visit her at night or during the day?
Oh, it was during daytime hours, never at night, no.
Were you supposed to be working when you went to visit her during the day?
Objection, relevance. Could we approach?
You may.
Good.
Objection overruled.
You may answer the question, sir.
You have to ask that again, please.
When you were visiting her, were you supposed to be at work?
Sir, I didn't have an exact work schedule, where I just had started a new employer at the time, back in July of 2008. I pretty much went on the early afternoon or later afternoon for my employer. My employer was very lenient on hours, as long as I put particular hours in on a particular day.
And is it your testimony to this jury that you weren't going there for any romantic interludes? It was just because you were going there to console her for her brain tumor?
Objection asked and answered.
Overruled.
As I stated, sir, yes, I did go there just to console her, because she had confided in me that she had a brain tumor, or she was having medical issues, and she also explained that also to my wife, sir.
Did your wife go to her apartment too?
No, sir, my wife never went to her residence at all. No, sir.
So the only one that went to her apartment was you, not your wife, or you two didn't go together?
No, but my wife had knowledge that I was at her residence. I had nothing to hide, sir. Never have.
Did you, prior to finding your granddaughter, tell Crystal Holloway or River Cruz that Caylee's death was an accident that snowballed out of control?
Well, sir, to clarify your question, I never found my granddaughter. To this day, I've never found her. And to say that I had said something to her about, it's been stated, or even by you here, that something might have snowballed out of control, that conversation was never there. I never confided in any volunteers or any people I considered those friends that came into our family to help us out. Never confided in anything like that. I wouldn't do that. I was handling everything on my own, and with my wife and with my son. That was a private matter for us. If I was asked by you or the prosecution or the sheriff's department or the FBI or something about my granddaughter, or about my daughter, I was always given that information. I always gave that willingly, honestly, and freely as possibly as I could.
So just so we're clear, sir, you never told Crystal Holloway, while the two of you were being romantic, that this was an accident that snowballed out of control.
Assumes a fact, not an evidence. Asked and answered.
Asked and answered, sustained.
The answer is no.
Asked and answered.
I think,
Sustained.
Your Honor, I think the witness's answer was non-responsive, and I just want to be clear on the answer.
So the record to be clear is the answer yes or no, Mr. Anthony?
Would you ask that one more time, please?
You never told her this was an accident that snowballed out of control?
Never did.
Did you ever send her a text message telling her that you needed her in your life?
Well, I've seen that information come out. Yes, I sent many text messages to many, many volunteers and people are helping out. And yes, I did need those people in my life. Yes.
So you sent her that text message?
Yes, sir. I'm not going to say that I didn't.
Did you ever leave her any other letters that you were trying to get to speak with her?
I know on one occasion I stopped by her residence, just left her a letter. Yes, that's possible. What it was in the contents of it, I don't remember. If it was something to cheer her up, make her to feel comfortable what she was going through in her life, possibly I did. I don't think anything wrong with that.
If I can have just one moment, Judge.
You may.
Did you at any time ever tell her not to say anything about your affair with her?
Assumes a fact which is not in evidence.
If you made the statement or not, Your Honor.
I couldn't hear counsel's response, Judge. I'm sorry.
I couldn't hear the last response.
I'm just simply asking if he made the statement or not.
Overruled, it can answer the question.
Sir, I never had a romantic affair with Crystal Holloway, River Cruz, or whatever name she wanted to give you or the world. If I'm not mistaken, sir, she has a questionable past, okay? And if I can clarify that with you, she also has been arrested for fraud,
Judge, I want to move to
breaking and
strike
entering and
this
stuff like
answer.
that. She is not a
Mr.
very good
Anthony,
person, sir.
Mr. Anthony? Okay. Question simply calls for a yes or no answer, sir.
Ask that question to me again, sir.
Did you ever tell her not to say anything about your affair with her?
I'm going to say this again. I did not have an affair with her, so the answer is no.
And, sir, are you aware that she never did say anything about your affair until the police came to her?
Objection assumes a fact, not in evidence.
Sustained.
How many times would you say you spoke to Miss Holloway on the phone throughout the time period of October through January of October 2008 through January of 2009?
Well, again, I stated at the beginning I did not know her as Crystal Holloway. I knew her as River Cruz.
Okay.
As far as how many times, sir, I don't know. Could have been once, twice. It could have been 10 times. I don't know.
Did you ever speak to her late at night?
Not that I can remember, no. I don't believe I would.
If I can have just one moment, Judge.
You may. Cross-examination?
Mr. Baez didn't ask you this question, but when was it that you knew this lady?
I met her at our command center at the skating rink on Goldenrod sometime in the middle to about probably the third week of October.
Okay. So you met her sometime in the mid-October,
Mid-October 2008.
and after Caylee's remains were found, your friendship with her ended at some point in January. Is that
Basically,
correct?
yes, I would agree with yes, it did.
Did you ever tell River Cruz that while your daughter was home on bond, that you grabbed her by the throat, threw her up against the wall, and said, goes into statements by the witness,
Overruled.
threw her up against the wall and said, I know you did something to Caylee. Where's Caylee?
No, sir, I never did do that to my daughter.
No further questions.
Redirect? No further questions. May Mr. Anthony stand down. Thank you, sir.
Cynthia Anthony, Cynthia Anthony.
You may proceed.
Thank you, Your Honor. Morning, Mrs. Anthony.
Good morning.
Mrs. Anthony, did you ever instruct Dominic Casey and Jim Hoover to go search off of Suburban Drive?
No, sir, I did not.
Did you ever ask them to go videotape that area?
No, sir, I did not.
On December 20th of 2008, there was a search warrant served on your home. Do you recall that?
Yes.
Did you tell Detective Yuri Melich that you had your people walk that area a month ago and nobody was there?
I can't recall if I stated anything to Mr. Melich that day. We were just kind of upset that they were back during that time frame.
Do you know if you told him, if I can have just a moment. Do you know if you told him that you had people walk that area? Let me finish the question. Where the body was discovered a month ago and nothing was there in that area?
Again, sir, I don't recall specifics that I spoke to Mr. Melich about. I just remember being upset that he was in my home on the 20th of December.
Do you recall if you told him that you had some blankets missing?
I did recall telling him that there was a blanket missing.
And this was the second time they had searched your home since finding your granddaughter.
On the 20th, it was the third time. Oh, since
But
they
since-
found Caylee?
yeah,
Oh, it was the
since
second time. I'm sorry.
And the first time that they searched your home, they left a search warrant at your home?
On December 11th?
Yes.
No, sir, they did not.
Did they leave an inventory sheet telling you what they had confiscated?
No, sir, they did not.
So you have no idea what they were looking for or what they had taken?
Not on December 11th, no.
By the 20th is what I'm asking you. When they came for the second search warrant, did you know what they had confiscated on the 11th and what they were looking for?
I believe our attorney at that time did request the search warrant and the items listed, and at some point before then, we did get that.
So you were aware they were looking for Winnie the Pooh blankets? And bedding?
Well, there was 70-some items that they had taken on December 11th, so I really wasn't sure what they were looking for. I don't think I read the subpoena for December 11th. I think that it had, from my recollection, it was something to do with a sticker.
Prior to September 2008, did you tell your son, Lee Anthony, that you had sent Dominic Casey and or Jim Hoover to Suburban Drive to look for Caylee with a video camera?
I never told anybody that I sent those guys there because I never sent those guys there.
What about after? I know you've just answered, but I want to make sure about the time period. What about after or around the time of November 2008? Did you tell Lee or have an argument with Lee about sending Dominic to go and search in that area?
I had no knowledge of that search in that area, so I would not have had an argument regarding that. My first knowledge of that search was after Caylee's remains were found.
Okay. And you never had a discussion with him where he confronted you that, why are you looking for a dead Caylee?
Sustained.
I have no further questions.
Cross-examination.
Those issues.
Witness may stand down. Thank you, ma'am.
Thank you, sir.
The defense may call the next witness.
Defense calls Lee Anthony.
Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God? Yes, sir, please.
Lee Anthony, Leeanthony.
Good morning, Mr. Anthony.
Morning.
Mr. Anthony, did you ever have an argument or discussion with your mother about sending Dominic Casey to look for Caylee off Suburban Drive with a video camera?
Yes, sir, I did.
And can you tell us what happened?
Absolutely. I was over at my mother's house, and we had a
Hearsay.
And it's also hearsay.
It's not hearsay. Yeah.
Well, sustained as the narrative. Rephrase your question.
Did you go to your home, your parents' home?
Yes, sir, I did.
Okay. And when you got there, did your mother tell you anything about sending Dominic with a video camera to Suburban Drive?
Hearsay?
Overruled.
Yes, sir, that did happen.
What did she tell you?
That she sent Dominic into the woods off of Suburban because she got a psychic tip that she wanted to follow up on.
Okay. And when did this conversation take place? Approximately.
Time or date or?
The month of 2008.
It was later in the year. I don't recall exactly. I'm sorry.
Would it have been before you went back to work?
I believe it was.
Okay. And when did you go back to work?
I went back into work. I would have started back sometime in October.
Of 2008?
Yes, sir.
So prior to October 2008, you had this discussion with your mother?
That's my recollection, yes, sir.
And did it create an argument between you two?
Might have been one-sided on my part. Absolutely. I was quite angry.
Why were you angry?
It was the first time I'd ever heard anyone in my family offer it up that they were willing to look for a deceased Caylee. Because prior to that, not even within the realm of anybody's mindset. So I was quite angry.
Thank you, sir. No further questions.
Cross.
Good morning, sir.
Good morning.
You had this conversation, you had this alleged conversation with your mother in October or before October of 2008?
Well, I don't know the exact time frame for sure. I went back to work approximately in October. I know the conversation happened prior to that because it fueled my decision to go back to work.
You're aware, or are you aware, that Mr. Casey went into the woods in November?
That's my understanding, yes, sir.
So you had this alleged conversation with your mother before the event actually took place.
If that's the only time he did that, yes, sir.
Okay. Thank you.
You're welcome.
May the witness stand down.
Actually, if I can have a moment.
Mr. Anthony, what do you mean it fueled your decision to go back to work?
Made my decision a lot easier to return to work instead of being out of work during that period of time.
Why?
Overruled.
Scope of the cross,
It was brought up during cross.
when he went back. I didn't ask him any questions about his employment.
Overruled.
I was very angry that my mom specifically, but my folks decided to do that without keeping me in the loop. And it was something that for me, I couldn't believe that they were even considering that Caylee would no longer be with us and they'd be willing to look for her that way. And I frankly didn't want anything to do with that. So I decided shortly thereafter that I am indeed going to go back to work and try to focus some of my energy across the board.
Thank you. No further questions, sir.
Recross as to those issues.
So into October of 2008, you were completely sold on the lies that your sister had told you.
Scope for redirect.
Overruled.
Yes and no.
Thanks. I have nothing else, Judge.
May the witness stand down. Yes, sir. Thank you, Mr. Anthony. You may stand down, sir. Subject to recall.
My name is Yuri Melish, Y-U-R-I-M-E-L-I-C-H.
You may proceed.
Thank you, Your Honor. Detective Melich, I'd like to direct your attention to December 20th, 2008, when you executed a search warrant at the Anthony home. Do you recall, sir, when executing that search warrant, that Mrs. Cindy Anthony had stated to you that she had her people walk that area, meaning where the body was recovered, a month ago, and nothing was in that area?
I recall her saying something to that extent.
Okay. If I showed you a copy of your police report, would that refresh your recollection?
I have a copy here, too.
Oh,
I can look
okay.
at that.
So you recall that? Or can you look it over and make sure that you're... It would be on page 9, Bates number 3382.
I have a different report. I have a compilation of my reports, so just bear with me, please.
Sure.
Yeah, I recall she had made that comment. It was in front of Corporal Edwards. I don't have an independent recollection of the comment, but obviously I wrote it down, so.
Okay. And that there was nothing in the area then?
I can only attest to what I wrote in the report, and that she stated she had people walk that area, meaning the area the body was discovered, a month ago, and there was nothing in the area then.
Okay. I have no further questions.
Cross-examination. None. May the detective stand down, subject to recall.
Yes, sir. Subject to recall.
Thank you, detective.
Thank you, sir.